Everyone, this is the City of Syracuse Board of Assessment Review. It is Friday morning, February 23rd, and just wanted to open up the meeting here. Just as a reminder, these meetings are recorded and available to be viewed on YouTube, and we have the address to that if necessary. So just making you aware of that. We'll do a roll call. My name is Joe Saya.
Straub.
Carl Masterful.
Michael Babins.
Donna Moore.
Okay, thank you. And let's see here. The first property we have is 453 North Salina Street. Yeah. Just, it's Friday, it's dyslexic Friday, just in case anybody was wondering. Yeah, right there's fine.
Good morning, thanks. Hopefully, this will be one of the easier things you reviewed today.
I'm gonna swear you in and then just read some stuff in.
Okay.
And then I'll turn it over to you.
Great, thank you.
And we'll swear the board in initially as well. Okay, if you can raise your right hand and your right hands, okay. State your name for the record.
Martin Jacobs?
And Gallagher.
Does everybody swear to tell the truth, the whole truth and nothing but the truth, so help you God?
I do. I do.
Okay, great, thank you very much. That'll take care of that. And so once again, this is 435 North Salina Street. I'll just read in a little information
It's an exemption,
here.
just so you know.
Oh, it's an exemption issue? Okay, very good. Thank you for that. We have a two-story building. First floor is used as a commissary kitchen for educational purposes, and the second floor is classroom and storage space. Okay, I'll read the note. Is it a full exemption question?
It is.
Okay, so I'll read the numbers in anyway, and we'll take it from there. And I just want to confirm. Okay, and this will be number one, of course, on our schedule, 435 North Salina Street. So we have a current tentative assessed value of $354,000 with a land value of $24,000. That would be a market value of $566,400. The petitioner believes the market value is $190,000, and that is a assessed value of $118,750. Again, it's a question of full exemption. And I just want to flip through. The property was purchased for $190,000 on June 23rd of 2023. Like there was an exemption denial, and we got some further paperwork as far as applications are concerned. All right, so let me, if you want to tell us what the situation is, if you can try to speak in the mic.
Yeah, absolutely. So, as you mentioned, we purchased the property on June 23rd from OSIDA. Prior to that, it had been leased by OSIDA had been leasing it to OCC, Onondaga Community College, who had then been subleasing it to Syracuse Urban Partnership, which is also a not-for-profit, who is using it as the exact same form as it's being used today, a commissary kitchen. Syracuse Urban Partnership, that not-for-profit, is also the owner of Salt City Market, so it was kind of in partnership with that concept. Then OSIDA approached Syracuse Urban Partnership to purchase the building because it was no longer being really used by OCC as its original purpose. Unfortunately, Syracuse Urban Partnership cannot purchase property as a requirement of its new market tax credits, which is a whole other complicated piece related to the Salt City Market. but similar members affiliated with Syracuse Urban Partnership had created a new not-for-profit called Seed Syracuse, so that we could purchase more property in the future. One example of that being the Chimes building that we recently purchased. Anyway, Seed Syracuse ultimately purchased the property from OSIDA after it being getting an assessment of $190,000. So that happened, and then Seed Syracuse has leased it to Syracuse Urban Partnership for $1,700 a month, so that it continue to be used exactly the way it is again today, which is a commissary kitchen for food-based businesses on the first floor. It's rented out hourly to individuals who are considering starting a business. It's also sometimes used by groups like Center for Community Alternatives to do line cook trainings and classes. So at the time, had met with the commissioner, had suggested that we apply for the exemption that for not-for-profit use, that shouldn't be an issue. It was denied, and was curious as to why. And then it was discovered that somewhere in the records, it still was assumed that there were 2 apartments on the upper floors, which is not the case. Those had been taken out, I believe, in 2014 when OSIDA redeveloped that property initially. So toward Commissioner Oja through the property. Oja, thank you. When did we go through? I think in mid-January to confirm that there were no apartments there, that it was just classroom and storage space. And so that's when I then filed this grievance to confirm that it is being entirely used for not-for-profit purposes.
And on our end, we're correcting the roll via the errors and omissions process to reflect the inventory and a change to the assessment too, because obviously, the very dated second floor office space is of a very different value than an apartment might be.
And that's what's being used for the classes?
Yes, there's sometimes classrooms, classes occurring on the second floor, but really the bulk of the use of the property is the first floor commissary kitchen for educational purposes.
This is the With Love, the old With Love?
Yeah, it's the old With
restaurant?
Love, yeah.
And do they still, are they going to serve food to the public on the first floor?
Nope, food is not served on the public. It's not like.
They used to, right?
They used to.
Yeah.
Yep, they used to as a restaurant, but then when that was closed, we started to use it as this commissary kitchen instead.
Was taxes being paid on this building prior to this purchase?
No, it was an
Because it was
OSIDA.
OSIDA.
Right.
Okay, so it's been off the rolls for a little bit. We need the revenue. So anyway, based on all of that, are we in line with the exemption?
Yes. Yeah, this is,
And that's a full exemption?
It's a whole exemption. You know, the rent and fees really needs to exceed carrying costs, I think, for us to justify getting it onto roll section 1 at $1,700 a month for, I don't know, square footage handy, but for this space is significantly below market. I think Martin's got a better insight into exactly how this relates to carrying costs, but it is, it does not cover their nut, so to speak. So yeah, I think we're okay with this.
Okay, all right, well, you heard it.
Okay, appreciate it.
And, yeah, thank you very much for coming in.
Yes, thank you.
The city will send you a notice first week of April.
Okay, fantastic, thank you.
Thank you very much. I'm just going to go on record saying that as far as exemptions are concerned, what's the percentage of the city property that's exempt?
There's a lot of ways to quantify that metric, and I'm going to sit in this very seat maybe that's neat if I get here first, in about a month for our budget hearing and be asked that question and put a pretty detailed number behind it. But last year was the first year in a while that we arrested a pretty bad trend, but I think it was 52% and low change.
Yeah, I thought so. The Common Council, they've got to, they're using city services. They've got to correct this exemption thing. Every property should not be fully exempt, in my opinion. And they've got to look at that. Is that something that you would suggest?
Oh, gosh,
The New York State law, though. I mean,
Oh, so it has
the
a-
guidelines are from New York State, not locally.
Okay, and can they not supersede New York State as far as Syracuse is concerned? It's, anyway. I
we're
thought
in
I
a
would,
position where obviously we are aware of certain realities, market or otherwise, but certainly are bound by real property tax law. Do our best to sign a roll reflecting that.
Yeah, I understand. Okay. So next property here is 715 East Fayette. Good morning, how are you?
Good morning. How are you?
Good, thank you.
I'm Craig Dillinson. I'm the representative for the property owner, and this is Stephanie Kim, who is my paralegal. I
Good morning.
asked Stephanie to be here today because she did all the research on the comps and the background work. In case you have questions, you might be better suited to answer than me.
Okay, no problem. I'm going to read the property in, and then I'll read a few things in, and then we'll get to you guys. 715 East Fayette. Let me just find it. Okay, so let me just find the application. Probably in the binder, okay. Thank you for that. Okay, once again, 715 East Fayette Street. Let me swear you both in, if I could. If you could raise your right hands, state your name for the record.
Craig Dillinson.
Stephanie Tim.
You both swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay. If we can, I just want to make sure we can get it on record here. Should we give another mic? Do you think you're going to speak a lot, or?
No, I have an introductory.
Okay, just try to speak in the mic if you can.
Will do.
We're getting some feedback that it's getting a little tough to hear type thing.
Okay.
So this, once again, 715 East Fayette Street, this is vacant, empty lots. And let's just confirm some numbers. We have a current tentative assessment of $720,000. Is that right?
No, that's the full market.
Yeah, that's what I have here, but over here, okay, so what's the current tentative? 450?
450,000, yeah.
Okay, I see what you're doing here. 450,000. And then we have a full market value of 720,000. Petitioner believes the fair market value is 300,000 with a equatable assessed value of 187,500. And let me just see if I can pull. It's purchased in October of 2020. Do we know what it was purchased for? It says see Schedule A, so it's what was an allocation deal or something, or?
Subdivision.
It wasn't really purchased, it was swapped land with their neighboring partners, and then he
Okay, yeah, yeah.
There were multiple lots that were separate from each other. And then the neighbor and he got together. When I say he, is Brian Sivan, who's the member of the LLC. They got together and they just thought it would be best for all the property owners if they exchanged some property and then just consolidated their lots, and that's what they ended up doing, of course, with the cities. That was in, I think, October of 2000.
Okay. All right. What else can you tell us?
Well, prior to the exchange of the property, my client's total assessed value of the multiple parcels that he had at that time was $30,500, and it consisted of 30,562 square feet, all those lots combined. We didn't calculate it in acres. Then after the re-subdivision and the exchange of the property, he ended up with a single parcel with total square footage of 24,525 feet, which is actually 6,000 and some change square feet less than prior to the re-subdivision. And again, at the time of the exchange, the multiple parcels he had, which actually contained more square footage, had assessed value of $30,500. After the re-subdivision, the assessed value of the new single lot was increased in 2023, I believe, to $375,000, and then it currently is at $450,000. So the assessed value has been increased despite the fact that he's actually owns less land. Now, this is totally unimproved property. It's just grass and vacant property. There are no buildings on it. It's not a parking lot. It's not paved or even has stone on it or striped or anything of that nature. What he bought it for originally was to develop housing units, and I asked him why he's never gone forward with that, and he said because of the change in the economic conditions since he bought it, that the price of materials has gone up considerably, as we all know, the labor costs and so forth, and he said that with the calculations that he's done of how much the rental income they could generate from putting housing units on there, it doesn't justify at this time developing it into that. So I asked him why he was just holding on to these vacant parcels, for the last several years, and that was his explanation. Gas station, and the assessment for that property is considerably lower than my client's assessment for completely vacant property.
Summed it up and kind of made some charts in there for you to kind of have that visual.
A lot of information which we will go through. Anything you want to interject?
Yeah, I mean, we'd love to see the comps if the board is willing to share, and we've provided comps to the board too that we're happy to share with the other side. It does seem like we have a size discrepancy here, we're comfortable with the size of the property. GIS backs us up on it. We've got just over 30,000 square feet, and I know we've got the resub map someplace downstairs, so we can have another look at that. But yeah, we put this resub through for the 21 roll, which by operation of law obviously triggered the new assessment. And I do think we've had at least one equalization change since then, 20% increase for the 23 roll, no change for the 24 roll. Based on our understanding of the size, we're at about $14.50 assessed, about $23.50 full market, and we've got comps all day, including the constituent parts that made up this current property when it was purchased in 2017, purchased for $750,000, plus or minus 100 square feet, similar in size. I think it might have had superior frontage then. I don't remember if the southwest corner of Foreman and East Washington was then part of the lot, but now it isn't. But either way, plus or minus the same lot. So it sold for $24.50 a square foot in 2017. Given the appreciation we've seen, Midtown, foot of University Hill, I have every confidence that it's worth probably more than we have it assessed for right now.
was going to say, you're at 7:20.
Yeah. Truth be told, I think we're light. I do recognize the difficulties the developer has gone through with the round church apartment construction. So we're certainly not looking to be heavy-handed, hoping to facilitate that within our discretion, adhering to the RPTL. But I think we're comfortable with this one, and the data back us up.
Any thoughts?
Well, the $750,000 purchase price, did that include the church?
No.
Just the lot?
Just the land, yeah, which were several non-contiguous lots, both on East Washington, I think Foreman also, although I'd have to double check, and obviously East Fayette.
And that was back in 2017.
Yeah.
And as I mentioned, the total assessed values of the multiple lots was only $300,500 back then.
Yeah, those were legacy assessments, probably from the reval in 94, 95. That was, well, at the time of the reval, obviously, was an absolute no man's land. Not to put too fine a point on it. It's just not in the same stratosphere now as what it was then. And in 17, too, things have tightened. I mean, 800 East Fayette sold for $121 a square foot as a parking lot. There's an apartment building on it now. The data on the subject, pre-resub, is what it is. 701 and 709 East Water, which are encumbered by some pretty stringent environmental covenants, sold a block north of this for $29 a square foot in 22. It's as high a demand neighborhood as exists in central New York.
And you mentioned, have you seen the comparables that we?
No, I'd love to give those a look.
Would you want us to provide those? Because I think they're really telling. Those are similar properties today, in today's, world.
Sales comparables or assessment comparables?
Their assessment.
Oh.
Yeah.
Are they
Well-
not in here?
No, they are.
Yeah, okay.
Yeah.
All right.
So
No,
I guess my question is, do you want us to provide those to you separately? We can drop off a package, or will you do that?
No, I think,
Yeah, thanks. No, we're happy with the board facilitating.
Yeah.
And likewise with ours. As a rule, I mean, sales comps are a reflection of the market. Assessment comps, for any number of reasons, are a little flawed, for one reason or another, whether an assessment might be based on a legal settlement, or any number of other factors that just contributes to it being an imperfect snapshot of what a property's worth.
I understand, but if I might, sale comparables, wouldn't they, and I'm not looking to increase the other neighbors' taxes or assessments, that's not what we're here, but wouldn't they affect their assessments as well? The same property?
Certainly, yeah.
Same
I mean,
area?
we oughtn't to be well, not to get too far into the weeds, but the resub represented a physical change for the property. So while the 15th Ward typically gets reassessed every other year at worst, and we should be reassessing the entirety of the neighborhood or the ward at a time, this was a reassessment of just this property. So that put some attention onto this parcel that another property owner might not get without a change in the property. But again, as a neighborhood with steady appreciation, our assessors are on every block, certainly east of Almond Street to the 16th Ward line. I would have to say annually. So I think sales comparables should have set the assessments pretty well on par for everybody in the neighborhood. So,
Reassessed, you said, what, every other year?
should be every other year. I wouldn't be shocked if it's every year over there at this point. It's not a huge neighborhood. Many of the parcels are large, and again, it's just the hottest neighborhood, certainly in the city of Syracuse. So we find it in everybody's best interest, I think, to stay on top of that.
Yeah, and I can understand that. I guess what I don't understand is if, since 2020, this property, my client's property, has been reassessed, and you're looking at sales comps. If you're reassessing in the entire ward every other year, I'm just a little confused as to why the other properties, because we looked primarily at the comps and said these are very similar, even larger parcels
No,
that are
I-
assessed for significantly less than my clients.
I share your curiosity about that. I'll look forward to seeing the comps, and I'm sure there's some logical reason, but eager to see.
Okay, thank you.
Okay, anything else you want to add? No? Okay. Well,
We did just confirm with county mapping while we were sitting here that just under 30,616 square feet, which is actually 30 square feet off from what we got from GIS and is in our system. But yeah, probably want to have a meeting of the minds, at least on the size of the parcel. Well, I think we're good on that, but probably want to correct that misunderstanding too.
okay. All right, so a lot of information which we will go through, and the city will send you a notice first week of April. Okay? But thank you very much for coming in.
Okay, thank you all.
Appreciate it. Did you have relatives on Brattle Road?
I grew up
You grew up there?
there. Yeah, Billingson,
Yeah.
10 kids.
Yes. Yes.
And once you,
My name's Joe Saya.
oh, Joe, yeah, okay.
So, yeah, I remember from the,
Everyone remembers us.
Yes.
With all those kids.
oh, yes, no, that's right. Are you the oldest?
No, the third.
The third.
Yeah, George was the oldest, is the oldest, Mark, and then me, Craig.
All right, and then who else? Because I'm trying to get down to where I was.
Would you go to Henniger?
Yeah.
Yeah, what year?
84.
That was probably, I was 74, so that was probably Stephen, or, well, Beryl Sue, my sister.
Yes.
Yeah,
So she might have been in the same grade.
yeah,
Yes, that's who I remember.
yeah.
And then there was probably a boy around that age also, I think.
Neil?
Yeah, Neil.
Yeah, yeah,
Okay.
he lives in Tully. And
Okay.
she lives in Brewer, where's she live? Brewerton. Yeah. She knows her.
That's right.
There's so many of them, I can't.
Thank God you brought her. Well, great to see you.
Nice to see you.
Yes, and
Yeah.
tell Beryl and Neil I said hello.
I will,
Yeah.
yeah. Great.
Funny that you bring up my sixth grade.
Oh, my God, really?
Wow, we all know each other.
Can I tell you that Stephanie says hi?
If I had known that, I'd be
Wonderful.
relaxed.
No kidding. Were you Stephanie Tim then? Or-
No, I was Stephanie Lobello then.
Get out of here. Hi, good to see you.
That's great. Just because we know each other, I won't hold that against you as far as
In case my brother Neil gave you a hard time.
he did actually, so when you get the notice, you'll know what happened.
Tell him. Good to see you.
Same here.
Thank you.
Thanks.
Okay. So we have 317-19 South Salina and 1700 West Genesee Street. Good morning, how are you? So we'll swear you in a moment. Is there any particular order you wanted to do these in?
Well, maybe we'll start with the Geddes, if that's okay. 1700 Geddes Street,
Geddes or Genesee?
Genesee, sorry.
Yeah, no, that's okay. Okay, so I'm going to swear you in,
Okay.
and if you can try to speak in the mic, that'd
Sure.
be great. Can you raise your right hand?
Yes.
State your name for the record.
Deborah Sullivan of Barclay Damon.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. Okay, so we're here for two properties. And the first one is 1700 West Genesee Street.
This is an exemption issue,
Are both or just this one here?
just this.
Just this one here, okay. Is that a full exemption?
No, it is 45A.
485A?
A, yes.
Okay, so just to clarify, 485A means,
A conversion from commercial to residential and commercial.
oh, okay, okay. So that is a partial exemption?
Correct.
Okay. All right, we'll get into the meat of that then. Let me just make a note here. 1700. So once again, 1700 West Genesee Street, commercial and residential. Current tentative assessment of $1,248,000 with a land value of $40,100. That would be an equatable market value of $1,996,800. Okay, now, petitioner believes the market value is in fact $1,996,800, which
We're
will,
not disputing it because
of the,
exemption issue.
yes, understood. And then therefore, the assessed value of $1,248,000. Okay. All right, why don't we get into the particulars as far as the exemption issue?
Sure, so this actually involves a really interesting issue. This property was granted an exemption in 2019. Dave Clifford inspected the property and granted the exemption under 485A, which, as we've talked about, has a partial exemption. This law went into effect in about 2002, but it could be adopted by upstate cities. It was directed at upstate cities. They had tried something similar in New York City in the 1990s because of the glut of commercial, vacant commercial property, particularly office properties. So in the early 2000s, this statute was enacted for the specific purpose of revitalizing downtown areas with lower populations than New York City. So the target was, Buffalo, Rochester, Albany, Syracuse, upstate. And if you take yourself back to what downtown looked like in even the mid-2000s, it used to be said you could roll a bowling ball down Salina Street and not hit anything. So there was downtown looked a lot different. So the goal of this legislation was to spur development. And to do that, they had found that in New York City, offering this kind of incentive helped create incentives for developers to make the investment in the property to convert vacant buildings into some kind of mixed use. So Syracuse did adopt by local option this favorable exemption. It's you don't pay any taxes, I think, on the increase for 8 years, and then over the next 4 years it gets phased in, the taxes. So this is in 2019, this property was approved for the exemption and got the exemption. Well, in 2020, there were some amendments to RPTL 485A. And I think there had been discussions that there was some perceived abuse of this section. Because if you actually look at the statutory language, and this comes through, I pulled all of the legislative history, it was a vague statute, okay? So one of the abuses that got cited was there was a project in Buffalo, so it's supposed to be mixed use, commercial and residential. There was one apartment. The rest was all commercial. And they didn't feel that that maybe met the spirit of what was required. There's the vending machine example, and then there's the example of basically none of the existing building being left, only vacant land, and then properties qualifying for 485A. So fast forward, this exemption had been in place in many places 10, 15 years. Certainly in that time, I would say our own downtown had been transformed favorably, to used to be very easy to find a parking spot, even on the weekend. Now, even during the week, it's tough to find a parking spot. So I think it had the desired effect, but the legislature felt there had been abuses. So in 2020, they wanted to tighten down, tighten some of the definitions. First, they wanted to say how much had to be commercial and how much residential. And I think in 2020, they were saying 50% commercial and 15%, I'm sorry, 50% residential, 15 commercial. And they added a certification provision and got away with the idea that you can have vacant land that applies qualifies for this exemption. That statute, and I'm going to give you, it was actually Bill Magnarelli from here who was the sponsor. I've got a few copies here.
Thank you.
So if you forward to the very last page, it specifically says the effective date, January 1st, 2020, and shall apply to properties for which the initial application for exemption are received on or after such date. Well, I would say here it's undisputed that the subject property is grandfathered. These new provisions do not apply to it because its exemption application was received before the effective date of the statute. But that wasn't the end of the story, believe it or not. The governor did not like the 2020 amendments, and he ratcheted down how much had to be commercial from 50, I think, to 40, and the vacant land exemption part, that did not qualify was of a huge concern to him. So that didn't make the final cut into the 2021 amendments. So the statute that we have today in 2024 is from the 2021 amendments, and there are clearly differences, but the key thing here is this property's exemption was removed on this 2024 assessment roll, and we believe improperly so based upon when the statute went into effect. And attached to the grievance, there's a way on Lexis that you can compare what was in effect in 2019 to the current one, and in the application that we attached, we provided that document from Lexis, and everything in green is new. So anything you see in green does not apply to the subject property because it was grandfathered under the prior legislation. And I did want to point out also, I've attached from this legislative history, I attached to the grievance, this is from the Division of Budget, who is concerned about the public purse. It states, first, this bill would only apply to new applications for exemption filed on or after January 1st, 2021, and would not impact current beneficiaries. So, big picture, I think if you take yourself back to the time that this statute was enacted, downtowns were suffering, and the legislature chose to enact a very vague statute, not a lot of standards. In fact, there was some talk in the legislative history that ORPS was going to provide some regulations, and ORPS sent a letter and said, no, we don't have that authority. It's from Richard Sinnott of ORPS, who says, since the text of the proposed only refers to the state board as having to prescribe an appropriate application form for exemption, I assume that the reference to rulemaking is superfluous, particularly in light of the Court of Appeals' extremely narrow reading of the board's authority in matters related to exemptions, and he cites a case. So I think, looking back, with the benefit of hindsight in the legislative history, a vague statute was enacted, and assessors were put in the somewhat maybe untenable position of having to figure out what the statute meant and how to apply it. And, only with the benefit of hindsight where, now the development has occurred, do people look at it and say, this isn't within the spirit of what was enacted. But if you ask me, the legislature knew what it was doing because Vagueness in some ways maybe helps spur development. If you start putting too many constraints, people are not going to be motivated to redevelop properties. So they let it play out for a while, and then, 10, 12, 15 years in, they decided it was time to put some constraints. And they have done so. And I think assessors, quite frankly, took a lot of flack from newspapers and whatnot that they allowed these, but when you read through the legislative history, it was not on the assessors. It was the legislature who enacted something that was vague, so they have the power to tighten it up, and they did in 2020, and they did it prospectively. So based on all of that, and I'm happy to leave all of this legislative history if anybody wants it, but it's our position that the exemption should not have been removed. It was granted under the old law.
Okay, all right, so it was enjoying the exemption, and then it was removed as of this tax roll?
Tentative roll.
This tentative roll, right? And how much of an exemption was there in place? Was it?
Oh, it's still in the meat of the exemption. Everything over base is exempt.
Okay. All right. So,
Well, this year, all recipients of the 485A were sent renewals to show us leases that, they were still being rented and so on and so forth. So 140 applications went out. We asked for leases, instead of us visually going to each parcel to verify, because there is such a law that says, we can ask that to make sure that they're still being used as commercial and residential. So there were a few that were questionable as far as leases and uses go. So I inspected the property with Debbie and
That you